And you are live.
Great, thank you. We are back at House Education, January 22nd. Shifting gears, one of the things that will continue to come up as we discuss transformation in education is how we deal with tuitioning and where the money goes, what's allowed. And a lot of that is been sort of shaken by a Supreme Court decision that we're going to get a briefing about. So I'm going to turn it right over to our legislative counsel to provide an excellent.
Thank you, Beth St. James, Office of Legislative Counsel. Would you like me to share my screen?
Yeah, let's do that.
Okay. So today we're going to talk about a U.S. Supreme Court case called Carson v. Macon. It is most commonly just referred to as Carson, and how that interplays with Vermont's town tuition program. And this is a presentation I've given for a couple years now. I haven't really changed it at all, so, but it's usually it usually sparks more questions and is a longer presentation than 45 minutes. So I'm gonna just kind of move through everything, and if I am confusing you or you need some background, please tell me to slow down and we'll go into some of the concepts in more depth. Does that sound okay?
Yes, great.
Okay.
you show.
Sorry,
You can cut it.
my phone is on silent.
Okay, so what are we going to talk about today? So we're going to talk about the U.S. Constitution and the First Amendment. We're going to talk about 3 U.S. Supreme Court cases. We're going to talk about Vermont's town tuition program, the Vermont Constitution, recent legal challenges to the town tuition program, and I say recent because there have been legal challenges that date back many decades. We're not going to talk about that today. And then just a very brief touch on where are we now. Okay. The U.S. Constitution. We're going to talk about the First Amendment today. What do you all think of when you think of the First Amendment? Okay, great. It's not what we're talking about today. We're going to talk about the Freedom of Religion Clause. So actually, the first clause we're going to talk about is the Establishment Clause, which is Congress shall make no law respecting an establishment of religion. And then the Free Exercise Clause, or prohibiting the free exercise thereof. Together, that's what we think of when we think of the First Amendment and the Freedom of Religion Amendment. So Congress shall make no, it's kind of 2 clauses for one concept. Congress shall make no law respecting an establishment of religion. That's kind of what we think about when we think about the separation of church and state. Or prohibiting the free exercise thereof. And then just a concept that we're going to talk about is strict scrutiny. So when a court looks at whether a law or an action is constitutional, they are reviewing that law and those actions against various different standards. And in order for a law or an action to be upheld, to be considered legal, it has to jump over certain hurdles, depending on the rights that are being infringed. And the highest hurdle that a law or a behavior has to jump over is strict scrutiny. And that is that the government action must be narrowly tailored to advance a compelling government interest. And so when we're talking about fundamental rights, which freedom of religion is a fundamental right, free speech, the courts are gonna hold the government to the highest legal standard in order to determine whether a law or a behavior is constitutional. If there's, yep.
A compelling government interest.
Here's a fun fact.
Thank you.
In addition to you all making up the laws, courts make up laws, Congress makes up laws, right? This is, I am not a constitutional scholar. But generally speaking, and you'll see this in this presentation, the law is a living, breathing thing. And so what is a compelling government interest? There is no document that says these are all the compelling government interests. One side is going to be arguing that we are in support of this action or behavior and it is a compelling government interest. And one side is going to be arguing it is not a compelling government interest. And then it would be a court's job to decide. Now, when courts are looking at the facts before them and analyzing them under the law as it stands then, there is a concept called judicial precedence, right? So usually courts are relying on the cases that have come before the case in front of them to inform their analysis. But just as you can't bind a future legislature, courts are not binding on future courts. And I think the most obvious example of this is the overturning of Roe v. Wade last year, right? You heard the concept that this was legal precedent, this is legal precedent, this is legal precedent, and then the court came out with a decision that was the opposite of what cases before it had held. So, compelling government interests. So for comparison, so rational basis is the lowest hurdle that you have to jump over.
Okay.
And that the court is going to be looking at whether the law or behavior is rationally related to a legitimate government interest. Now we're talking about compelling government interest. And there's lots of case law discussing that term. For our purposes today, I would encourage you to think of compelling government interest as kind of like the highest calling of the government's
Thank you.
job.
Yeah.
But this is not black and white. This is and you will see, this is an evolving area of the law. This is actually quite a living, breathing area of the law. Confused so far?
That helps.
Okay, so the first case we're gonna start talking about, and again, anywhere you see underlined, there's a hot link there. So if you were to click on that, it should take you to the actual Supreme Court opinion. So Trinity Lutheran Church of Columbia versus Comer. Usually this case is just referred to as Trinity Lutheran. And this is kind of the start of the analysis that Carson relies on. So the state of Missouri, so you can see that the decision was issued in 2017. Obviously, we know it takes a long time for something to happen in society and make its way all the way up to the US Supreme Court. So case came out in 2017, but all of the conduct that happened before 2017. So that's just to orient you to where we are in time. So the state of Missouri funded a program offering grants to nonprofit organizations to resurface playgrounds. The state denied grants to religiously affiliated applicants, including Trinity Lutheran Church. The US Supreme Court held that Missouri violated the free exercise rights of Trinity Lutheran Church when it denied the church a generally available public benefit solely because of its religious status. Questions? Yeah. So, if we're talking about the freedom of religion and we're talking about the two clauses, the Establishment Clause and the Free Exercise Clause, we're talking, the Supreme Court here is saying you can't deny this public benefit state to a religious organization just because they are religious, because they have status as a religious organization. So seems a little bit more protective of the Free Exercise Clause than of the separation of church and state, the Establishment Clause.
Mhm.
Can I ask a question? This might be speculative, and I understand if you say I can't answer this, but it's reminding me of an issue that came up in our town in trying to give out ARPA money this year and a church applied, and our reasoning for the church was that we needed to give it to public facilities and not churches. So would that kind of be the same thing here?
Ooh, I have no idea. I'm not gonna speculate.
I thought you might say that.
But, if you follow this, with the presentation along, I would hope you have some questions.
Okay.
Okay, so the next case happened the opinion was issued in 2020. Espinoza versus the Montana Department of Revenue. We commonly refer to this as Espinoza. So Montana established a program that provided tax credits to people who donated money for private school scholarships. The scholarship program prohibited families from using the scholarship itself at private religious schools because Montana's state constitution contains a no aid provision, which prohibits government aid to any school controlled by a church. I will just say, there is so much that goes into every single one of these cases that I am not going to touch on, including there's a lot to say about the various state constitutions and the clauses in them that talk about state aid and religious organizations. There's a long history there and it's very different in every state. And for today's presentation, we are not going to get into it. That's a special caveat for the people that know what I'm talking about. I said it. Just like in Trinity Lutheran, which came out 3 years before it, the US Supreme Court held here that because the scholarship program is a generally available public benefit, that phrase is really important, disqualifying otherwise eligible recipients based solely on their religious status or character violates the free exercise clause of the First Amendment. So this is a direct quotation from this case. A state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious. Now, Montana made arguments that they were not actually disqualifying private religious schools because of their status, but instead because the scholarship money would be used for religious purposes.
Right.
The court declined to make a distinction between status and use-based discrimination in this case because it found the status-based discrimination to be so clear. It left open the question of whether there's a distinction between the two.
Can I ask another
Yeah.
question? So what about the religious schools that might discriminate and have be in violation of states like discriminatory policies, like not accepting certain kids for certain reasons or?
That is an excellent question. That is what I have been referring to as the next frontier, and that is not a part of this presentation, but it is the natural next presentation.
Okay.
So Supreme Court said, okay, we hear you, that's a clever argument, but your discrimination is so clearly based on status here, we're not going to comment on whether or not you can discriminate based on whether the money is going to be used for religious purposes. And then literally everyone, including this legislature, debated whether there's actually a distinction between use-based and status-based discrimination for 2 years. In my first session with the legislature was in 2022, and there was a bill that the Senate worked on that involved the town tuition program, and a lot of that debate was around whether there can be a status-based versus a use-based discrimination. And then that bill didn't go anywhere. In 2022, the Supreme Court decided to tell us how it is. So Carson v. Macon. So a little background here. Maine has one of the, if not the only similar tuition program to Vermont in the country. Maine allows school districts that do not maintain a high school to pay tuition to the private school of a family's choice. Maine required, past tense, participating schools to be non-religious. It actually said that in their law. Families that wanted to use state tuition dollars to send their children to religious schools sued. And Maine argued that it would not exclude a school from receiving tuition solely based on its religious status. Right? Supreme Court's already told us we can't do that. So we're gonna say we are excluding them based on whether the money will be used for religious purposes. And the US Supreme Court held that Maine's non-religious requirement violates the free exercise clause of the First Amendment, prohibiting the bar of religious organizations from generally available public benefits based on the religious use of the benefit. So the Supreme Court is saying, not only can you not deny a generally available public benefit based on the religious status of the organization seeking that benefit, you cannot deny that public benefit based on the religious use of that benefit.
So is the language in our constitution pretty similar to the language in the Maine state constitution?
Oh, that's a great question. I don't know.
Okay.
Hang on, hang tight.
Okay.
And I'm sorry, how much, I know you pushed me back, but I didn't check.
We pushed you now into, 12, parallel 15.
Okay. Okay, so what about the establishment clause? So far, we really only talked about free exercise, right? The government can't prohibit the free exercise of religion, but there's that other part of the First Amendment that talks about separation of church and state. What about that? So in 2002, the US Supreme Court held that when government benefits flow to religious organizations through the independent choice of private citizens, there is no violation of the Establishment Clause. Because all three of the previous cases involved the First Amendment, which is a fundamental right. The court applied that highest, you had to get over the highest hurdle, the strict scrutiny in its analysis. And what the Supreme Court said is an interest in separating church and state more fiercely than the federal Constitution cannot qualify as compelling in the face of the infringement of free exercise. So if the US Constitution and the US Supreme Court, who is the deciding voice on what that Constitution means, says that for every state, for all United States, this is the threshold to which you can separate church and state. If a state decides to go beyond that because they believe it's a compelling government interest, the US Supreme Court is saying that cannot qualify as a compelling government interest if it's butting up against the infringement of the free exercise clause. So if the state is saying our interest, our government action is so compelling that we believe separation of church and state is warranted here, if it infringes on someone's free exercise rights, and it's going beyond what the US Supreme Court has said is okay, the US Supreme Court's never gonna say that that's a compelling government interest. And the court found in all three of the previous cases that states were attempting to create a stricter separation of church and state than the federal Constitution requires. So when the court decided Trinity Lutheran, Espinoza, and Carson, it looked at all of those states' constitutions and all of the facts in front of them, and it made decisions based on the facts in front of them. I'm highlighting this because the Supreme Court has not looked at Vermont's constitution, but it is tipping its hat a little bit, right? The analysis is going to be the same. The Constitution, the language in the Constitution is going to be different. The history and how that language came to be is going to be different. And the facts of the case and the plaintiffs and the defendants are all going to be different. But the analysis is likely to be the same. And that is an interest in separating church and state more fiercely than the federal Constitution is not gonna cut it. So, Vermont's Town Commission Program. very similar to Maine's. So here, school districts are organized to provide education for specific grade ranges. And if the school district does not operate a school for some or all of the grades it is organized to provide education for, it still has to provide education for its resident students. To do so, a school district may pay tuition to the school of a student of choice, either public schools or approved independent schools. We've already talked about this a little bit. It is family choice. There's also the concept of designation, but there's only one school district that does that here, so it's kind of a moot point for this discussion. But it is a legal option on the books right now. Unlike Maine, Vermont's statutory tuition program is silent towards religion. Tuitioning decisions are made at the individual school district level. So this is not the state deciding whether a kiddo gets to tuition to a school. That's an individual school board decision if there is a conflict. So if Vermont's statutory tuition program is silent towards religion and Maine's called it out, why do we care? Why are we here? Well, Vermont has what we call the compelled support clause in our state constitution. And it reads, no person can be compelled to support any place of worship contrary to the dictates of conscience. And in 1999, we have a very seminal case, and this is where the conflict comes in Vermont. So this is a Vermont State Supreme Court case that was issued in 1999. If you remember, the cases we were talking about from the US Supreme Court started in 2017. So big time lapse there. So Chittenden School District did not maintain a high school, so it paid tuition for its high school students, including to religious private schools. At the time, it was the Department of Education. It was not the Agency of Education. So in response to this, the Department of Education terminated the state education aid to Chittenden. They got no money. And then the Chittenden School District turned around and sued the department. In analyzing Vermont's compelled support clause, the Vermont Supreme Court found there was no way to separate religious instruction from religious worship. The court was careful to note that the compelled support clause did not create a blanket ban on public funds being used in religious schools. Instead, the court found that a school district violates the compelled support clause when it reimburses tuition for a religious school in the absence of adequate safeguards against the use of such funds for religious worship. Are there any words in there that cause concern for you now that we've talked about First Amendment jurisprudence and Trinity Lutheran, Espinoza, and Carson? Anyone? Bueller? Okay, thank you. In the almost 24 years since Chittenden was decided, no branch of government has developed standards for the adequate safeguard concept. But as of the date of this presentation, Chittenden remains good law. So, we have the US Supreme Court telling us that a state cannot create a stricter separation between church and state than the federal constitution requires. And we know that the federal constitution does not prohibit religious funds or public funds in a generally available public benefit from going to religious organizations for religious use. But we have the Vermont Constitution and our Supreme Court's interpretation of the Vermont Constitution that says you cannot send Vermont funds to a religious school unless there are adequate safeguards to protect against the use of that public money for religious worship. They're in conflict with each other. But the way this works is it's school boards are left having to make these decisions on their own in their community based on the legal advice that they receive from their council, weighing First Amendment jurisprudence and our own compelled support clause jurisprudence without a court of ultimate jurisdiction deciding them and telling them what the final answer is here for Vermont. And I say this because in the realm of possibilities, right, the Supreme Court looked at Missouri, Montana, and Maine's constitutions, and they said, you are not so special that you can trump the First Amendment's, the threshold of the First Amendment as far as separation of church and state. But no one has told Vermont that they are not so special yet.
Can I just ask for what would be some examples of adequate safeguards that would stop this?
I have nothing for you.
That's a terrible question.
I mean, that in the almost 24 years since Chittenden, a court did not come out with it. The executive branch did not come out with it, and the legislature did not legislate that. No one has. So I don't have an answer for that question. I'm saying all of this just to be super clear that in the universe of possibilities, is it possible that someone could challenge public money going to a religious school in Vermont and it make its way all the way up to the Supreme Court, and the Supreme Court looks at the unique history of Vermont and the unique language in Vermont's constitution and the unique makeup of Vermont and
You're talking about
says,
the US Supreme Court.
yes,
Yes.
and says, we found the unicorn. We found the most unique, special place where your compelling government interest in creating the separation between church and state is actually okay. In the universe of possibilities, that exists until the Supreme Court says it doesn't. When we are looking at judicial precedent and what the US Supreme Court has told us, is that likely? Is that something we're gonna hang our hats on? I don't know. It is an open legal question. Until the US Supreme Court says otherwise. Now, there's liability on both sides of the aisle here, right? And so if you are a school district having to make a real world decision in the field about whether you're gonna follow the jurisprudence under Carson or Chittenden, your lawyer should hopefully be explaining all of this to you, but also the liability involved in making one decision over another, right? And so I have the benefit of my job is not to tell you how a court should rule, how a court will rule. I'm just helping you understand the legal landscape so that you all can make decisions. But you are likely to hear in the field, or I would not be surprised if you hear local counsel saying, no, you gotta follow one or the other. There are so many reasons that go into legal advice based on the facts and the relationship of each of those situations that are different from my relationship with you all. But this presentation is meant to highlight, you've got the First Amendment in Carson, and you've got the compelled support clause of Chittenden. And right now, both of those cases are good law and they conflict with each other. Clear as mud. Okay. So there has been some recent, both federal and state litigation. So everything on the left-hand side, the federal litigation has all settled. The French cases, and they're all French cases, which is the name of our former Secretary of Education. But AM, AH, EW, and Valente were all challenges in some respect that involved the town tuition program in a denial of funds to a religious school. The facts and the situations were different in each of these cases, and the arguments were different in each of these cases. They've all settled, and whether a case settles or, ends up with a court making a final decision can be very meaningful, because when parties settle, no one is usually ecstatic about the outcome. It's negotiation, everyone's giving a little. And it's an agreement, it's a contract between the parties that the court ultimately has to okay. So depending on the terms of any settlement, it may or may not impact or have control over how the next case is going to be decided. But if a case goes, we call it on the merits, if it goes all the way, if there's litigation and there's a hearing and witnesses and evidence and a court makes that decision, usually that legal precedent is going to have control over the next cases that come before it. Settlements can, most of the time they don't, because what parties are looking to do is limit their liability and get out of there.
Are settlements, secret, like, are the settlement terms public, or does that?
For these
say-
cases, yeah. For these cases, yeah. Every case is a little different, but generally speaking, yeah, if the case is public, the terms of the settlement are going to be somewhat public. Not all the time and not all terms in every case. Nothing in my world is ever black. Then there was, so this was all on the federal side. And then there was state litigation, on, the name of the case was Vitale, and that was, a challenge to whether the town tuition program violates the common benefits clause, which is, we did not talk about here today, but that's basically that, taxpayer money should not be going to just one population and one group, right? It should be benefiting all of a class. And so the argument here was, well, not every kiddo gets the option to tuition. And so it's a violation of the common benefits clause. And the Vermont Supreme Court found the plaintiffs failed to allege facts to connect school choice with better educational opportunities. And they essentially did not state a claim upon which really could be granted. But the court said, our conclusion in this case does not end the evolution of the debate over how the state should educate Vermont children. So where are we now? So as a result of the settlement in those cases on that left-hand column, the Agency of Education was required to issue some guidance to school districts. And they did so on September 13th, 2022. And to my knowledge, this is still good this is still the guidance that is out there. There's a hot link to the actual guidance on the agency's website, but here's a quote. In light of the U.S. Supreme Court's decision in Carson v. Macon, we are writing to advise you of the following. School districts may not deny tuition payments to religious approved independent schools or religious independent schools that meet education quality standards based on the Vermont Constitution's compelled support clause. But school districts are tasked with making those tuition decisions on an individual basis, taking both the Carson and Chittenden decisions into consideration.
This may be too far into the weeds, but this is getting interesting. It says may not deny tuition payments to religious approved independent schools or religious independent schools that meet educational quality standards. Yet that's not a requirement to be an approved independent school.
No, but there is a whole category and there's separate tuitioning provisions for an independent school that does meet education quality standards. There's some differences in how tuition is calculated, and they would qualify to participate in the former school construction program. And so there's some different benefits available to them.
But
It's not a requirement to be an approved independent school now.
I guess what I'm asking is, so to my knowledge, no religious school that is an approved independent school meets education quality standards, has chosen to go that path.
That would be a question for the field. I'm not aware of any schools that have actually meet education quality standards.
There's one, or two.
I think they're in process, but I don't know whether they've been deemed to meet that status.
Well, so my question is being that if you're not meeting EQS, can payment be denied based on the language here?
No. I don't think this has anything to do with whether or not an independent school is meeting EQS. And there,
Well, it says you may not deny tuition to a school that meets EQS. So therefore, does that mean that you can deny tuition to a school that does not meet EQS?
this is saying you can't deny tuition to a religiously affiliated independent school.
That meets
Yeah.
education quality standards.
So I think, I didn't write this. I think what is meant here is that there's two different categories. There's approved independent schools, and then there's independent schools that meet education quality standards. And if they are religiously affiliated, you cannot deny tuition to either of those categories of independent schools if they are religiously affiliated, based on their religious affiliation. There may be other reasons why you're denying, right? Because maybe they don't.
Oh, I'm sorry, now that I'm reading it.
Okay,
There's an Oregon that,
Yes.
fixes everything, thank you.
there's so much more to talk about here. This is meant to be foundational.
Yep.
And to give you, a working knowledge if this comes up. To have something to reference to, or to run to my office and say, I know we need to talk about this.
So I might, do you feel comfortable talking about, where things stand in the, independent school approval process and the requirements and sort of the legal limbo there?
A little bit, so yeah. So in order to be in, 16 VSA 820, section 828, defines which schools or which educational programs are eligible to receive public funds. And included in there, that's how we get that. You hear everyone talking about, recognized independent schools are not eligible for tuition. We know that because they are not listed in section 828, only approved independent schools, and a whole host of other educational programs that we're not going to talk about. So, approved independent schools are, regulated essentially by the State Board of Education. There is section 166 in Title 16 is the approved independent school and recognized independent school statute. It talks about the process and some requirements to be an approved independent school. But the main regulation standards come through the rulemaking process, and the State Board of Education owns those rules. The legislature has given pretty broad authority to the State Board of Education to promulgate rules for the approval of independent schools. That's it. There's some other, there's some other framework, but, it's pretty broad. And so the State Board of Education, right around when Carson came out, went through a large rule change with their approved independent school rules. And included in that was a requirement, and then there was another, amendment of the same rule series last year, I believe, that carried over this, requirement that in order to be an approved independent school, you had to essentially follow the state's anti-discrimination laws. And there was a requirement, created, for an attestation. When you are, approved independent school approval is good for, generally speaking, 5 years. State board can change that, but it's generally 5 years. And then you would go through a renewal process. And as long as you're in your 5-year window, you're just out there operating as an approved independent school. When you come up for renewal, now there, I believe, an attestation process where you have to confirm that you are meeting certain standards that are not perhaps independently verifiable, such as you have fire alarms and safety things. And so one of the pieces on that attestation is following anti-discrimination laws. There were some schools that were up for renewal and kind of put a little asterisk on their attestation, and that caveat varied from school to school. They were religiously affiliated. And the general argument is, and I'm not speaking on behalf of those schools, I'm just speaking on behalf of the general argument in this area is, following anti-discrimination laws, strict compliance with anti-discrimination laws may cause a religiously affiliated organization to violate their closely held religious tenets. And that is a violation of the free exercise clause of the US Constitution. So there are some cases, and so there have been some lawsuits against the state for this requirement. And there are some lawsuits that are winding their way through the federal court system. I believe they have gone from, there was a request for, I think there's 2 cases, I think. Litigation is incredibly long and drawn out. What often happens when a benefit is being denied is someone files a complaint to kickstart the process. Here are the facts of the case and here are the laws that we think have been violated. And then there's a whole host of due process requirements and procedural requirements that kick in related to the defendants filing an answer, the discovery process, yada, yada, yada. That takes forever. Meanwhile, the person who's filing that complaint is still being denied that benefit that they believe they will triumph and be due. So how do you kind of fix that? There's this process called an injunction. They can request an injunction where it's a temporary either stop or grant of a benefit while the litigation continues and we figure out the ultimate outcome. So there was a request for an injunction in this case saying, we don't think we should have to comply with the anti-discrimination laws, or we think complying with the anti-discrimination laws is a violation of our First Amendment rights. While courts, you figure it out, we would like to still be eligible for public tuition. I believe that injunction was denied. So the court found in favor of Vermont in requiring compliance with the anti-discrimination laws. And the result of that, the injunction, the denial of the injunction has been appealed, I believe, to the Second Circuit where it is being briefed and litigated. And I haven't looked it up recently, so it's possible that there's an opinion out there and I have not seen it. But what this is all getting to, and there's actually the exact same thing happening in Maine right now. So Maine, after Carson, they have a education, like an anti-discrimination law in their education statutes that's specific to educational environments. And they have a similar requirement in there that came out after Carson. There's a whole separate, the analysis is going to be a little different based on the context, but there's also cases winding their way through Maine and the First Circuit for Maine's town tuition program requiring religiously affiliated schools to comply with the anti-discrimination laws. So the federal court system is broken up into 9 different circuits. And Vermont is in the Second Circuit and Maine is in the First Circuit. So not only are they dueling state, there's going to be dueling federal opinions. They could be the same. They could also be separate. So what this is all based around is there is this case called Smith, came out of Oregon, and I'm going to get the year wrong. It was either the late 90s or the early 2000s, and it stands for this principle that if a law is generally applicable and neutral, so it applies to everyone equally, it's not calling out one class or one group over another, then it can infringe on fundamental rights, because society has to function, right? If there was a carve out for every law, for every protected class or right, it would be very hard for society to function. So there's this general legal principle that if a law is generally applicable or neutral, it can infringe on a fundamental right. So if a law applies to everyone, such as you gotta follow the anti-discrimination law, and it's neutral, it doesn't say, including you religious schools. Perhaps under the Smith theory, it might be okay for Vermont and Maine to require those schools to follow the anti-discrimination laws because the law is generally applicable and neutral. Now, what generally applicable and neutral means is the next frontier, and that is what is being debated. And this is an area of the law that is ripe for change. And I say that because there was a US Supreme Court case in 2021 or 2 out of Philadelphia, where there was a challenge based on a law to a religious organization and whether that law was generally applicable or neutral. There was a little bit of a get out of jail free card there, but there was some dicta and at least 3 different Supreme Court justices concurring opinions that they don't think Smith should be the controlling law anymore. So they've tipped their hat that this is something they're going to continue to talk about. So all of this to say, this is very much an unsettled area of the law and has the potential to create huge precedent nationally for this concept of generally applicable and neutral laws and how they are applied, in this case, to religious organizations. And that's, again, a whole separate presentation with so much more to it. But so right now, I believe the underlying case of ultimately whether Vermont can require a religiously affiliated independent school to have to comply with the anti-discrimination laws in order to be eligible to receive tuitioning is still being litigated, and the injunction piece, which involves an analysis of where the court thinks this analysis is going, is being litigated in the Second Circuit. And I think it's likely that either Vermont's case or Maine's case is going to go up to the Supreme Court.
So we'll wrap there, but that is just to say that, a whole sort of thing that we've all had to learn is that what we do, we have to think of it in the terms of, will it be appealed? What is the likelihood that it would reach the Supreme Court, and what is the potential Supreme Court decision on it? So it's all a bit of a difficult path to go. Great,
Great,
and
thank you.
we'll about to get perhaps some more clarification from the state board. That's our next round of testimony.
Great.
Thank you.
Thank you.
We'll reset the